This hearing's called back to order at 9:43. Okay. For the record, a quorum is present. We are meeting to consider proposed non-renewal of term contract for Carolyn D. Ross. This hearing will be conducted in open session pursuant to Mrs. Ross' request. However, if for any reason during the hearing in open session it becomes necessary to go into closed session, the hearing will be moved into closed session permitted by Open Meetings Act. I know that the employee requested an open hearing through her representative via email communication on May 24, 2016. Ms. Ross, do you still wish to have this hearing in public? Okay, thank you. If the administration is being represented, will the administration representative please state your name and whether you are a licensed attorney?
My name is Robert Russo. I am a licensed attorney, and assisting me today is Mr. Jameson Baker, who is also a licensed attorney. The district is being charged for only one of us.
Thank you. Appreciate that.
I had to say that.
I love that. It's no problem there. If the employee is being represented, will the employee's representative please state your name and whether or not you're a licensed attorney?
My name is Judge Jim Conley. I'm former Justice of the Peace in Precinct 4. I am not licensed in any jurisdiction. I was licensed in Texas and Pennsylvania. In 1993, some people in my office did things that the bar decided I should have been responsible for, and they suspended and then ultimately removed my license. I'm here as her personal representative, and have tried more than 100 jury trials and have multi-million-dollar verdicts in medical malpractice and pharmaceutical device cases. I've tried cases in court martials from Lodges Field in Portugal to Panama to Hawaii. So I bring at least some degree of experience. When I first came to San Antonio, I was employed by the law firm of Hardberg and Herrera. Mr. Phil Hardberg, the former mayor of San Antonio and the former Chief Justice of the Fourth Court of Appeals. I was elected Justice of the Peace. Before that, I was Chief of Misdemeanor Section for the DA's office. And as I said, I tried more than 100 jury trials, and I'm here representing Ms. Ross. I'm proud to be representing her. I've known Ms. Ross for some time. Thank you.
Thank you, sir. And legal counsel for the board is Ms. Laura Fowler, seated to my left. Okay. The superintendent recommended to this board that the contract of Carolyn D. Ross not be renewed for the next school year based on information attained during the course of investigation following an audit involving handling of school funds. The board on May 19, 2016, after considering the recommendation and reasons for the recommendation, proposed non-renewal of Carolyn D. Ross's contract and instructed the superintendent to cause to be delivered written notification of that proposal. The employee received the notice of the proposed non-renewal on May 20, 2016 at Metzger Middle School, the campus to which she was assigned prior to being placed on administrative leave. On May 24, 2016, Ms. Ross, through her representative, requested this hearing before the board. The hearing is being held within 15 days of the request for the hearing as required under Texas Educational Code 21-207. I will now ask each member of the board whether he or she is able to serve as an impartial member of this hearing body and to arrive at a decision based solely on the evidence presented at this hearing. Any member not able to act in such a manner may say so and ask to be excused. Mr. Salinas.
No problem, sir.
Mr. Salinas has no problem. Ms. Bashaw.
None at all.
Mr. Shaw has no problem. Dr. Salinas.
Okay.
Dr. Salinas has no problem. Mr. Macias.
No problem.
Mr. Macias has no problem. Mr. LaFoyle.
No problem.
And I, Steve Shire, have no problem. I will now instruct the parties on procedures to be followed during the hearing. The hearing will be conducted in accordance with Judson ISD's policy governing non-renewal, policy DFBB local. The administration's representative will present evidence establishing the reasons for proposal non-renewal. The employee may then present whatever evidence she desires to rebut the administration's case or otherwise to support the renewal of her contract. Both sides may present witnesses and documentary evidence and may cross-examine witnesses offered by the other side. Neither party has the ability to require the attendance of any witness. The board members sit as a panel of judges and are to remain impartial. At no time is it ever proper for any representative or witnesses to question any of the board members. To provide the most accurate record possible, the court reporter's transcript for the proceeding is being made. Please avoid talking when others are speaking so that the court reporter's transcript will reflect the proceedings accurately. Please also try to speak loudly and slowly so the court reporter can hear the accurate transcribed testimony. The general rules are as follows. Number one, only one person talks at a time. No interruptions are allowed except to assert a legal objection. 2, objections asserted shall be addressed to me for my decision. The representatives are not to argue directly with each other. 3, any person attending this hearing may not talk or in any way interrupt the proceeding. Any disruptive behavior by any person attending this hearing, as decided by me as the board president, presiding officer of this proceeding, will result in their expulsion from the hearing room. All hearing participants shall conduct themselves with a common courtesy and respect for all rights of others. 5, unduly repetitious or irrelevant testimony will be ruled out in order either upon the objections of either party or by my own motion. The hearing is being conducted by the Board of Trustees. The Texas rules of evidence are not applicable here. If any evidentiary objections are made, I will rule upon them to the best of my ability with the advice and assistance of the board's counsel with the proceeding, Ms. Laura Fowler, and considering the guidelines and interpretation of evidentiary matters provided by Texas Commissioner of Education. I appoint Sarah Murphy of the Hoffman Reporting of San Antonio as our clerk. Okay, thank you. Who is a notary to serve as clerk, swear all witness, and receive and label all exhibits and documentary evidence. Will the administration representative identify all the witnesses who are present?
Yes, sir. I think present at this time are Ms. Gomez, Jesse Cortinas, Jose Elizondo, Nato James, Teresa Ramon, Irma Hernandez, and Josephine Juarez, and Officer Larry Day.
Thank you.
There will be one witness by phone. She's not present, be sworn in at this time.
Okay, thank you, sir. Will the employee identify all her witnesses who are present, sir? Mr.
Yes, Your Honor. I'm sorry.
Not an honor. I got promoted, but that's not it.
Yes, I believe Teresa Barr has been here and has exited. Ms. Barr has exited. We have one by telephone, which is Lisa Butler. Ms. Barr?
Ms. Barr, yeah.
She should be excluded under the rule. She should be excluded at this time,
Okay.
but she's to be sworn in.
Well, we got to swear them in first, okay? Is that anyone else? Nope. Ms. Murphy, will the witnesses please rise, and Ms. Murphy, will you please swear them in?
Please raise your right hands. Do you solemnly swear or affirm that the testimony you will give today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Under authority of Section 551.084 of the Texas Open Meeting Act, all witnesses will be required to leave the hearing room until they're required to present evidence other than administration's employee representative, Ms. Irma Hernandez and Ms. Ross. A waiting area is provided for you. Chief, if you all follow Chief Gonzalez, will both parties agree to identify other witnesses who arrive later so they may be sworn in and placed under the rule?
Yes, sir.
Okay. If you
Yes.
have anyone else come in, is that okay? The hearing will proceed as follows. Each party will provide a chance to make brief opening statements. The administration's legal representative then will present witnesses and employees. Representatives may cross-examine each other. Witnesses, after the administration representative concludes direct examination of each witness. The administration's representative may conduct redirect examination with each of those witnesses, with the employee allowed recross following any redirect examination. That's a mouthful. Each side shall have 2 hours to conduct their examination, and we'll have 2 hours, no matter what time Everybody will have their whole 2 hours if they need it. The board will be the official timekeeper of each side. Dr. Salinas will be our official timekeeper, and will consider whether additional time is required by either party should the allotted time expire and the party requests more time. If any extra time is given to one party, the other party shall be given the same extra amount of time. Each party will be given 5 minutes to make an opening statement, another 5 minutes to make a closing statement. Dr. Sleeves will keep board time. Okay, are there any questions regarding the procedures? Mr. Russo?
Not regarding the procedures, but I would ask, since the board at its prior special meeting approved the minutes of the board meeting of May 19th, 2016, I would appreciate that the board would make that a part of the record of this proceeding.
Yes, sir, that's fine. What we just approved prior meeting, the board meeting, we'll get that to you, okay?
Oh, okay.
I will provide a copy to the court reporter,
Okay.
and I think we'll probably ask that it be marked as Exhibit 38, which is where we left off of our exhibit list.
Okay, thank you. Mr. Conley?
39.
39? Okay.
Okay. Mr. Conley, anything, sir?
I had previously filed, yesterday, filed an objection to the district's exhibits number 23 and 37. Do you have a copy of that?
I can
Mr.
dig
Sawyer,
through it.
I'm going to object right now. That's something that should be taken up when I offer those exhibits, not at the beginning of the proceeding.
In interest of,
Because of the technical difficulties council had, because his server crashed, which we take him as an officer of the court, as that having occurred, we are allowing his late filing of these objections, as if they were timely submitted.
Thank you.
And they submit those as a document
Yeah.
into the record.
I'm concerned that there may be some reference to the exhibit before it's often being offered, and I wanted to make sure that the board is aware that we do have objections and what our objections are, so that on the record, our objections are identified. And I would like to have opportunity to present them ahead of time as a pretrial matter.
Excuse me, I'm going to object to that. It's not a pretrial matter. It is something that ought to be presented to the board when I offer those two exhibits. That's the time where Mr. Conley can object, and I'll have an opportunity to respond. It's not a pretrial matter.
let me ask a question. Mr. Conley, do you know the exhibits were in there when the book was made? When we were? that they were
Yes,
coming
I don't
to
know.
you?
He indicated by his, he was kind enough to respond yesterday and saying that he was not going to include those two exhibits in the book that he gave you. And but that did not mean that he was not going to offer them at some point. And what those documents are, frankly, are at the core of the whole allegations that exist here. And they have no reliability, and our argument is that it's, first of all, it's hearsay, unreliable hearsay. He cited some cases where hearsay is used, but that was hearsay that is the kind that is reliable, that you can rely upon, is normally relied upon. That is not the case with these two exhibits. The hearsay that they're trying to present go to declare the truth of a fact by somebody who's not in court, and using that in the face of them discovering that what that person told them was countered and made therefore unreliable by at least 3 sources that said that what she said wasn't true.
Once again, that's a matter of the weight to be given the evidence, not the admissibility. And I would again object to having an argument over the admissibility of an exhibit that has not yet even been offered to the board.
Your objection is noted. It is up to each board member to consider the weight given to this evidence, so I'll allow it admitted because you said it has great weight on this case, sir. So I'm going to allow it to be admitted if Mr. Russo would admit.
Okay,
would admit.
and the point is that, as I understand hearsay, it's a statement offered for the truth of a fact that made by an out-of-court declarant, so making them not available for a cross-examination.
But, sir, this isn't a court, it's a hearing.
I
And
understand it's
we're
a
gonna-
hearing, you
Right,
know.
it's a hearing, and each side has the right to present anything they want, in this hearing, Now it's up to the board to consider the evidence and think if it's, important or not. Okay.
And the final objection, because I want to make sure
Sure.
my objections are on the
Yes, sir.
record,
Go right
so that
ahead.
when the commissioner gets it, he'll understand. Under 805A, 805, the fact that the district intimidated the witness so that she wouldn't talk to anybody.
Okay.
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 That she-
We're
no,
not going to
that-
get into
I'm
that,
saying.
sir.
Well, that's part of the
Here-
hearsay
Here's what's
rules.
going to happen, okay? The evidentiary rules do not apply to this hearing, okay? So I'm going to allow it presented. Your motion can be noted, sir, but we have to move on, and I.
And
you
I
have
want
the
to make
right-
my objection on the record.
Yes, sir.
I don't want to talk
appre-
over you. I want
I
you to
appre-
finish.
Make your,
All right.
for the record,
Okay.
sir.
And secondly, I object on it because it also violates our due process to encompass such unreliable, unprobative, and irrelevant information. And those are the elements of hearsay, elements of evidence. And hearsay can never, even if you could ignore it, just common sense, that their due process has been denied if someone will allow this kind of scurrilous stuff to be admitted when they have already collected facts that shows that they can't even rely upon it.
Okay, sir, again, it's up to each board member to consider the weight of the evidence given. This is not a court, it's a hearing, and it's up to the board members to hear the evidence and consider the weight of the evidence in their decision individually.
And I would represent that it goes to the weight of the evidence that the board, the district representative, did not disclose that they had contradicting statements to the very issues that this woman has raised. And they did not make them available to us. And so what weight can you have if you don't even know what the other information is? And we're saying that the fact that they didn't give us a copy of the written statements that contradict, that are diametrically opposed to what she's claimed, from people who are very reliable, from more than two sources, and they relied upon her statements to make the decision to vilify this woman based upon their own recognition that they ignored the other information. So that is so tainted, that is so scurrilous, that is so unfair. It violates every concept of due process,
Okay.
regardless of whether the rules of hearsay apply or not. It's just
Okay.
not fair.
I'm going to say again, we're going to allow them in there. Your objection is noted, sir.
Mr. Sawyer, I request an opportunity to respond to
Yes,
some of
sir.
the comments that have just been made.
Go ahead.
First of all, what I'm talking about are provisions from a December 2015 case, Los Fresnos versus Vasquez. And the key points I want to make is that hearsay is evidence. There are many exceptions to the hearsay rule. A non-renewal hearing is conducted by the board, not a hearing examiner, and the Texas Rules of Evidence do not apply. The board is free to admit and consider written statements to the extent it is not arbitrary, unreasonable, or otherwise unlawful to do so. And the employee has no property interest in the renewal of a term contract, and therefore due process is not applicable. Fairness is, but not due process. That is a particular legal concept that simply is not applicable to a non-renewal hearing. Under the government code, section 2000.081, evidence inadmissible under the Texas Rules of Evidence is admissible in a hearing if it is necessary to ascertain the facts not reasonably susceptible of proof under these rules, not precluded by statute, and of a type which reasonably prudent persons would rely upon in the conduct of their affairs. And at the time when it's appropriate, I'm going to offer exhibits number 23 and 37, and believe that the Vasquez case permits you to consider those pieces of information. And to the extent that Judge Conley is implying that we haven't provided information, there is not any provisions for discovery in a non-renewal proceeding. And in addition to that, there are two exhibits that have already been admitted into evidence in accordance with the agreement that indicate that the initial statement made by the witness whose statement I'm going to be offered under the provisions of Vasquez initially made a statement that was not the same as the one that I'm going to be offering into evidence. That appears in the two of the exhibits that I will be presenting. So therefore, I would respectfully urge the board, when it comes to the time when I present those two exhibits, that they be admitted into evidence and put into the notebooks that you have been provided with all the other exhibits that have already been accepted into evidence.
Thank you. We're going to move on, okay?
And I just want to extend again my objection to it, that it
Understand,
is
sir.
arbitrary.
Yes, sir. Your objection is noted. Per the opening statements from the parties, the district has requested that the board take judicial notice of a number of policies and 2 motions it passed on May 19th, 2016, dealing with the proposed non-renewal of Ms. Ross. The request is being granted. The following policies are hereby omitted and made part of the record of this proceeding. I have to read all these. CAA local, both current version and immediately preceding version made and omitted as Exhibit 1 and 1A respectively. CFD local, marked and omitted as Exhibit 2. DFBB legal, marked and omitted as Exhibit 3. DFBB local, marked and omitted as Exhibit 4. DH legal, marked and omitted as Exhibit 5. DH local, marked and omitted as Exhibit 6. DH exhibit, marked and omitted as Exhibit 7. DI local, marked and omitted as Exhibit 8. DI exhibit, marked and omitted as Exhibit 9. FNAB legal, marked and omitted as Exhibit 10. FNAB local, marked and omitted as Exhibit 11. GKG legal, marked and omitted as Exhibit 12. In addition to those policies, the board takes judicial notice of 2 motions that were considered and passed on May 19, 2016, marked and omitted as Exhibit 13, with the agenda for that meeting attached as Exhibit 13A. The remaining items have also been omitted as exhibits and made part of the record of this proceeding. Since the parties exchanged proposed exhibits, neither party has objected to these items prior to the deadline announced by the board. The district exhibits will be designated by numbers, and Ms. Ross' exhibits will be designated by letters. Okay, so we're going to move on. The administration.
Mr. President,
Yes, sir.
for the record, I would appreciate your indicating the exhibit numbers and the exhibit letters of those exhibits that are being admitted at the start of the hearing.
The whole thing. Okay, sure. Would you like them read in the record, or you just want the numbers?
Just the numbers, sir. I think
The
we'll be
numbers,
fine.
okay. We have here, 38? Yeah, I read the 14. Okay, 14, agreement signed by Ms. Ross regarding district acceptance and responsible use of technology and administrative procedures concerning electronic communications and data management, 12/11/2014. 15, Judson ISD Activity Fund Manual, August 2015. 16, cash handling training, copy of PowerPoint presentation, 2013-2014 school year. 17, annual activity fund review for acknowledgement form, 1/9/2014. 18, business signature card, Metzger Middle School Activity Fund account, 1/29/2015.
Can you please slow down?
Okay, sure, okay. 19, copies of checks from Metzger Middle School Activity Fund account, 2014-15 school year. 20, spreadsheet regarding checks with insufficient documentation found during 2014-15 audit and identifying missing requirements, prepared May 2016. 21, 2015-2016 term contract of Carolyn D. Ross, 5/27/2015. 22, witness statement of Chanel Gomez, 4/05/2016. 23, witness statement of Lauren Hopkins, 2/24/2016. 24, Judson ISD Police Department Incident Report, 2/23/2016. 25, witness statement of Deborah Stevens, 5/24/2016. 26, email from Charles Castillo regarding student activities late to class due to Bible study, 12/5/2014. 27, email of Sharon Stewart Thompson regarding Bible study disruption, 2/13/2015. 28, email from Carolyn Ross regarding tardies due to worship group, 4/10/2015. 29, email from Carrie Koch regarding pep rally for BBB team and girls soccer team, 1/18/2016. 30, email from Chanel Gomez regarding Star Pep Rally, 4/16/2015. 31, partial transcript of Carolyn Ross interview, 5/9/2016. 32, notice of proposed non-renewal, 5/19/2016. 33, Carolyn Ross requests for 21.207 hearing, 5/20/2016. 34, email from District Counsel R. Russo to Ms. Ross Counsel James Conley regarding board policies DFBB legal and DFBB local and setting out additional specific allegations of fact, 5/30/2016. 34A, email from District Counsel R. Russo to Ms. Ross Counsel James Conley regarding corrections to Exhibit 34, 6/1/16. 35, Lauren Hopkins acknowledged a refusal to meet with Irma Hernandez, provide testimony, 5/31/2016. 36, resignation exit form, Laura Hopkins, 5/31/2016. 37, transcript of interview of Laura Hopkins conducted by Irma and Nicole Dean, director, I think it's supposed to be Irma Hernandez and Nicole Dean, right? Right? Director of Accounting, 3/23/2016. 38, most recent summative evaluation of Carolyn Ross, 6/11/2015.
And then there would be 39, the
Right,
the board
39 and
minutes.
39 for the thing. Okay, right. And make a note that Exhibit 23 is not in the notebook and Exhibit 37 is not in the notebook. Okay.
May I approach? I have a copy of our exhibits.
Yes, sir. Yeah. Okay, thank you. Down there. These have a Pacific exhibit or you have a Pacific exhibit for these? These are just, okay, right, right. This is it. I passed them. I need one. I passed them down, sir, so you wouldn't have to. Thank you. I think he's got two down. Anybody need one? You've got an extra, that's yours. Okay, sir. Okay, I'd like to now read into Mrs. Ross's records here. Exhibit A, 6/8/14 Commissioners, Administrators, STDS. B, 6/11/15 Ross Evaluation Summary. C, 5/30/2016 Photo Metzger Banner. D, 5/31/16 Ross Professional Accomplishments, Judson ISD. E, List of checks with insufficient documentation. F, 5/9/16 copies of checks provided by the district. G, 8/15 excerpts from Judson ISD Activity Fund Manual, pages 8 through 13. H, 11/3/15 CAA Local, page 3. I, 10/22/09 CFD Local, page 1. J, 10/17/2012 GKG Legal, page 1. And J, 10/17/2012 GKG Legal. Anything else? We're good? We ready for opening arguments? Would you like to make a statement, Mr. Ross?
Yes, sir.
5 minutes. John.
On May 19, 2016, by a vote of 6-1, the board voted to propose non-renewal of the employment contract of Principal Carolyn Ross. On May 20th, the notice of that proposed non-renewal was delivered to Ms. Ross, setting out the following reasons for proposed non-renewal as set out in Board Policy DFBB Local. Failure to fulfill duties or responsibilities, incompetency or inefficiency in the performance of duties, failure to comply with board policies or administrative regulations, failure to meet the district standards of professional conduct, and misrepresentation of facts to a supervisor or other district official in the conduct of district business. On May 24, 2016, Ms. Ross requested a hearing, and as a result, we are here today for this non-renewal hearing that's being conducted in accordance with state law and district policy. To non-renew an educator's term contract, the district is only required to show that evidence supports one of its pre-established reasons for non-renewal. I submit to you that the evidence that will be presented to you today will support concluding that all 5 of the pre-established reasons for non-renewal set out in the notice given to Ms. Ross on May 20th are applicable to her contract. In her contract, in Section 5.2, Ms. Ross committed herself to comply with all board and district policies and regulations. I submit to you that the evidence that will be presented to you today will show that she has failed to do so. Time permitting, I anticipate that you will hear today from Chief Technology Officer Jesse Cortinas, Applications Coordinator Deborah Stevens, Chief Financial Officer Jose Elizondo, Assistant Principal Chanel Gomez, Assistant Principal Nato James, Chief of Police Teresa Ramon, Chief HR Officer Irma Hernandez, Assistant Principal Josephine Juarez, Police Officer Larry Day, and Ms. Ross herself. I believe that the evidence from those witnesses and from a number of documents that have already been admitted into evidence, you will be able to find the following. At an interview conducted on May 9, 2016, attended by district officials, Chief Human Resources Officer Irma Hernandez and Associate Superintendent Alita Berra, Ms. Ross misrepresented the facts when she stated that she did not know prior to February 23, 2016, that someone else had signed her name to school checks. At that interview, Ms. Ross misrepresented the facts when she stated that she never required or permitted her secretary bookkeeper, Lauren Hopkins, to approve purchase requests or other types of requests that Ms. Ross was required to approve as principal. At that interview, Ms. Ross misrepresented the facts when she stated that she never gave Ms. Hopkins her computer password to access Eduphoria. At that interview, Ms. Ross misrepresented the facts when she stated that she never told Ms. Hopkins that Ms. Hopkins could sign Ms. Ross's name to checks. At that interview, Ms. Ross misrepresented the facts when she stated that she never had Ms. Hopkins or any other staff members run any personal errands for Ms. Ross during school working hours. At that interview, Ms. Ross misrepresented the facts when she stated that she has complied with the policies and procedures that are required of her relating to receiving, keeping, and spending campus activity funds. At that interview, Ms. Ross misrepresented the facts when she stated that she followed the processes required of her for purchasing items for the school. At that interview, Ms. Ross misrepresented the facts when she stated that all work done on a private film concerning Neville Shedd being made by a production company in which she was a partner was done after hours. At that interview, Ms. Ross misrepresented the facts when she minimized her role in charging students to attend pep rallies. At that interview, Ms. Ross misrepresented the facts when she stated that students were not charged to watch movies during the school day. Ms. Ross, in essence, created a petty cash fund that she referred to as her pot, into which she placed funds obtained from students for participating in events or purchasing items that they should not have been charged for, and used those funds without following the policies and procedures for doing so.
30 seconds, Mr. Rizzo. 30 seconds.
I am going to submit to you that the evidence will indeed support finding that those items that were set out in the notice of Ms. Ross's proposed non-renewal establish that her contract should in fact be non-renewed. Thank you.
Thank you, sir. Judge Conley?
Thank you. Ms. Ross is here to challenge the non-renewal on two bases. First, she did not do any of the things that they claim she did, and that they're relying on the word of a proven liar to establish what the standards are. The evidence will show that the statements that she made to the district representatives were absolutely true, and that the statements given to them that they relied upon to say, because she said what she said, that the person who they already had lied to them at the very beginning came back, and then they told her that they needed her to come clean, and she started making up stories that they went and checked with people that she referenced, and the people said, no, it didn't happen that way, and it never happened that way. The evidence will show that the outrageous charge that she was somehow that she has somehow failed to fulfill her duties and responsibilities with the accolades and recognition that she's got not only from this district, but throughout the state and by the state. Incompetency or efficiency in the performance of duties, that's outrageous and scurrilous. I mean, there's no way. When you see her evaluation, her last known evaluation, these two must fail on their very face. The failure to comply with board policies and administrative regulations. You hear Deborah Stevens say that when she went in and talked to the secretaries about people using each other's passwords, there was a snicker among all of them. This is in the transcript. There was in her statement. There was a snicker, and so she had to reemphasize. These were all the secretaries from the district. Because they said, hey, you know, our people are really busy, and mundane things we try to help them through. And when it was brought to her attention, they said, well, you can give it to the assistant principal, which she did. And the assistant principal will be here to testify. I'm sure she's been called as a witness by them, but we'll certainly get into that. And the persons who claim that because she made a statement that is diametrically opposed to what the liar told them, that therefore she is misrepresented to them. Ms. Hopkins admitted that and we never got a copy of that first statement. Because her first statement, she went in and said, no, I didn't do that, I didn't sign signatures, I didn't do this, I didn't do that. And then she came back and said, okay, I did do them, and then I did some of them. And then she said, well, they asked her about the PTO funds, and she said, well, I didn't have anything to do with them, and then later she comes back and said, well, yeah, I just kept the cash here, and no, I never allowed them to open a bank account because I wouldn't send a letter over to changing it over to them. And then at the end, she says, when she leaves, she puts on her exit interview, the reason I'm leaving, not because I got fired for my nefarious activities, I'm leaving to go further my education. So she started with a lie, she lied all in between, and she lied at the end. And this district's representatives say because she said that isn't true, that she misrepresented to them. That fails on its face. And you'll see it from the evidence exactly what I'm talking about. So when I challenge the hearsay, it's not only hearsay because the person is not here to be examined, but it's hearsay because it's unreliable. And you can listen to anything you want to and put a weight to it, but I give this no weight. And the fact that they are using that as a foundation to say that she misrepresented to them what the liar started, in the middle, and at the end stated, fails on its face. Thank you.
Thank you, sir. Okay, now we'll go into presentations. The administrative legal representative may now present the administration's case. You have 2 hours, sir. Dr. Salinas is the timekeeper, so
Could I beg an indulgence?
yes, sir.
I have to drink a lot of water because
Okay.
of a medical
You want a
condition.
5-minute break?
Could we have a 5-minute break?
5-minute
so I can
break.
use facilities?
We'll be back in 5 minutes,
Thank you.
Jackie. Okay, 5-minute break.